Blake's contract. Anybody else, when they read her name, read Balake? If you know, you know. Okay. This is something that the public has sniffed out that I actually think has some really interesting legal issues with it. And it's going to take a couple of turns. And some of it's going to be like contract stuff that's a little dry. So bear with me. I promise it'll pay off in the end. So Blake Lively has brought two different breach of contract claims. One for breach of her actor loan out agreement, which is her primary employment agreement, and one for breach of the rider to that actor loan out agreement, which is the document in November saying here are the 17 things that are going to be fixed going forward. She needs those for her claims. In addition, as people have noted, the fact that she may or may not have been on contract or required to stay on this film could be relevant when it comes to her allegations of sexual harassment and whether Baldoni had the ability to affect her employment. In other words, if she wasn't under contract, couldn't she just leave? And the answer is maybe. But I think they have bigger problems, and let me walk you through it. So Lively cites in her complaint, and she cites it actually as the basis for why we're applying California law. She says, this is the choice of law in my actor loan out agreement, her original employment agreement. She has a corporation called Blakel Inc., which is probably her solely owned company, and they like loan her out as an independent contractor when she goes and does her work. Wayfarer created It Ends With Us LLC, and Wayfarer Inc. is the only member of It Ends With Us LLC. So these are their corporate sort of shells for their participation in this film. So what she has alleged is that Blakel Inc. contracted with It Ends With Us LLC for her to be an actor in this movie. The problem is, we don't know what that thing says because she hasn't attached it. She has not attached it. She has not given us like a cutout from it. And from a legal standpoint, that is very weird. Lawyers, back me up here. If you sue somebody for breach of contract, it is like law day one that you attach the contract or at least quote the contract in the complaint. So the fact that she's suing over breach of a document that she doesn't attach and doesn't quote from is super suspicious to me from start. Maybe there's something in there that she doesn't like. Now, the only insight that we do have into that original actor loan out agreement is the rider to that actor loan out agreement, which she did attach. So this is the November document where they list like the 17 things and say, going forward, this is what's going to happen. So a rider is like an addendum or addition to the original agreement, and it cites and references that original agreement. And its description of the original loan out agreement is the only place where we really get any information about what that loan out agreement might actually say. So if you look at the rider here, which is attached, it says this is an agreement, and it's referencing the original actor loan out agreement. And it says this is between It Ends With Us LLC and Blakel Inc. And when it references the original actor loan out agreement, it says dated as of May 5th, 2023. And I think that's where people are getting that maybe she didn't sign her agreement until May 5th, 2023. So maybe she wasn't actually required to stay on set until May 5th. And so if she had any of these alleged sexual harassment problems before then, couldn't she have just left? And doesn't that hurt the part of sexual harassment where it has to alter the terms and conditions of your employment because she technically wasn't even employed? And I think that that's a good argument. And I think that, yes, that's an argument that Baldoni's people can make. But I think it's actually worse for her than that. Because when a document says, we're going to get real nerdy, guys. When a document says dated May 5th, 2023, that doesn't mean that's when it was signed, and that doesn't mean that's when it's effective. Contracts can become effective through all kinds of different language. It can be that an argument or an agreement is dated one day but becomes effective a month later. It can be that an agreement never says when it becomes effective, and so it becomes effective by the last person who signs it. Saying something is dated May 5th, 2023 doesn't tell us when this thing actually went into effect. And then, as you can see here, the rider, it doesn't have dates on the signatures. That's a pet peeve of mine, by the way. I bet the business lawyers on here will back me up on that. Signatures should always be dated for exactly this reason, but there's no dates on the signatures. So if there's no dates on the signatures here, I wonder if there's dates on the signatures on the actor loan out agreement. So we actually don't know if that thing ever got signed. We just know that the rider says that it was dated May 5th, right? So then I thought, okay, maybe Lively's lawyers are going to try to argue that the rider is a completely separate contract, that it's like, it's independent. It was its own offer, acceptance, and consideration. It's not necessary. Its existence isn't dependent upon the actor loan out agreement to which it references. But then I went back and looked at the complaint and they basically say, no, this is a rider to that contract. They don't try to make the argument that it's independent. So number one, you've got breach of contract for a contract that wasn't attached or quoted from. And number two, another claim for breach of contract for a rider that's existence is dependent upon the original contract, which also isn't attached and isn't quoted. So this is all just like a hot mess. So yes, there are some real pleading deficiencies when it comes to her breach of contract claims, number one, which are like, I think, claim 8 and claim 9. And yes, I do think that creates a real question about that last element of sexual harassment is, did it affect the terms and conditions of her employment? Was she employed? When was she employed? Frank is very excited. Let's just assume for the sake of argument that we find out that the dated May 5th, 2023 actually means effective May 5th, 2023. Let's just go with that date, although I'm not sure that it is. That means that everything that happened before May 5th, so pre-production starting early in the year and getting all the way up to May 5th, which by the way is the same date that they allegedly did the HR webinar on appropriate conduct in the workplace. So that's weird. That means that during all of that time, it's possible that Baldoni has an argument that I couldn't have sexually harassed you. You could just leave. Now, the alternative to that, and I've said this before, is there is a concept in the law called course of dealing, which is where you say, look, I hadn't put the actual pen to the actual paper, but we were all acting as if I was under contract. And so therefore the contract kind of sprung into being because we were all acting as if it was. But that would be her burden to show. And there are other consequences for her of saying that she was under contract during that time. And I suspect that some of them are not good for her, which is why she hasn't attached it and we haven't seen it. Another thing that's weird, and this is real dorky, but it matters in business litigation. The entity that has signed both of these agreements is Blakel Inc., right? Which is typical. There's nothing wrong with that. But the only plaintiff on her side of the case is Blake Lively, the individual person. So they're suing in the wrong capacity. Now, they've made arguments that, well, Blake Lively was the beneficiary of these contracts, but every contract I've ever read has had there's boilerplate that says this contract's not intended to create any third-party beneficiaries. So I wonder, and by the way, if she doesn't want to sort of destroy it's called piercing the corporate veil, destroy the line between Blake the individual and Blakel Inc., because that takes away a lot of the liability protections, which is the reason that she created that thing in the first place. So yeah, I think this is a big one. I think we're going to see something in the motions to dismiss from Wayfair or Baldoni or It Ends With Us LLC about this contract writer, because I find all of this very unusual and very suspicious.